Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Professor Patricia Kane, and Patricia, I'll nickname to Pat, Professor of Law at Santa Clara University. She's been teaching law for over 38 years now.
Oh,
somebody
dear.
She briefly practiced law before she became a professor. She's a member of the Texas and Iowa bars and provides consulting services to law firms. Patricia is a frequent speaker relating to tax planning for same-sex couples and has written many law review articles on that subject. Today we're going to be talking about federal tax developments for same-sex couples. The date today, so that you know, is January 22nd, 2013. And as we'll discuss, the Federal Supreme Court will be hearing cases for same-sex couples during 2013. And I'm going to give you a caution that we're discussing issues in a very complex area. This is a starting point for a bigger discussion with your own tax advisor and attorney. Get qualified legal and tax advice. Also, we're mostly addressing issues from federal and California standpoints. For example, California is a community property state.
Right.
We have our own variety of community property in California. Community property in Texas, for example, is different. So viewers in other states should seek advice from about their local laws. Pat, thanks for joining me today.
My pleasure.
Glad to see you here. Okay, well, we're talking about tax developments for same-sex couples. So to sort of let people know how things have been changing, you know, where things stand at this point. The laws to both the status under state law and the status under federal law has been in a state of flux over the past few years. And so maybe you could update us a little bit related to the current status of the law related to same-sex couples.
Sure. Let me give a little background first.
Okay.
California in the year 2000 was the first year that same-sex couples were given statewide recognition as registered domestic partners. But in 2005, they were given the full rights and benefits of same-sex spouses, the most important of which of regular spouses. I guess we call them federally recognized married persons or FRUMPs.
Okay.
So the most important right, of course, was the community property rights. They were subject to the community property regime. There was one little trick, and that was in 2005, California did not allow same-sex couples to file their state income tax forms jointly. Now, the feds, of course, never would let you file jointly because they don't recognize the relationship of any type between same-sex couples. But 2005 was an important year. And then in 2008, same-sex couples who were registered began filing jointly. And also in 2008, the California Supreme Court held that there was a state constitutional right for same-sex couples to marry. And so we have a period in 2008 between June and November when 18,000 same-sex couples married in the state of California. And then the next thing that happened was Proposition 8 was passed, basically taking away that right of same-sex couples to marry in the future. So California is a very strange state. It recognizes valid same-sex marriages that occurred before Prop 8 was enacted. It recognizes registered domestic partners, giving them all the same rights and responsibilities as spouses. And under a law passed recently, California also recognizes couples from other states who are in same-sex marriages, but because of Proposition 8 simply can't call that marriage, but gives them all the same rights and benefits. All of those types of couples are subject to the community property regime, which in 2010, the IRS ruled informally, not in a published ruling, but in a private letter ruling, and then a chief counsel advisory, that yes, indeed, same-sex couples subject to community property regimes would be treated the same as spouses who had been subject to these tax rules since a very famous Supreme Court case in 1930, Poe versus Seaborn. So all community income is split 50-50, all deductions are split 50-50. That's created a little bit of a wrinkle in our laws.
Okay.
So, and of course, you now file jointly at the state level, but you file separately as single taxpayers or head of household at the federal level, splitting income and deductions.
Yeah. So it's a lot of fun doing these tax returns.
It's a little more difficult than it used to be.
Because, like, if you file married filing separately for federal, you have to file married filing separately for California.
But you can't file married filing separately
Yeah.
if you're a same-sex couple because your
Right.
marriage is not recognized. So
Right.
you're actually filing as a single
Yeah,
taxpayer.
Right. So you got two single taxpayers, and then they're filing as a joint return for California income
Right.
tax.
Which means they have to fill out an extra return, a mock federal joint return, which will not actually be filed, but will serve as the basis for the state return. That's
Right.
because of the Defense of Marriage Act,
Yes.
the law enacted in 1996 by Congress that said for federal purposes, including federal tax purposes, we will only recognize opposite-sex married couples.
Right. Okay. Well, anyway, now there's cases, and maybe you can discuss a little bit of the background for them, but they're before the U.S. Supreme Court. They're challenging the non-recognition of same-sex marriages. So maybe you can tell us a little bit about those cases and what's going on there.
Sure. There are two key cases before the Supreme Court in that the court has already granted the petitions for certiorari in those cases. One is the case that was litigated in California over Proposition 8. That's the Perry case. That's the argument that Proposition 8, banning same-sex marriage in the state of California, is unconstitutional under the federal constitution, under the federal guarantee of equality. And so far, at the trial level and at the Ninth Circuit level, courts have agreed with that argument and found that Proposition 8 does violate the 14th Amendment of the federal Constitution. So that's the question that's before the Supreme Court. Although, quite interestingly, they've also asked for another question to be considered in that case, and that's whether or not the proponents of Prop 8, who are the parties who actually made the appeal to the Supreme Court, whether they have standing to challenge. Usually it's the Attorney General of the state of California, the governor, who's defending the law. In our case, the state government has decided that they think Proposition 8 is unconstitutional under the federal law, and so they've stopped defending it. And so there will be a question about whether or not the proponents who are claiming that it is constitutional have standing before the United States Supreme Court. So it's possible that by June 2013, we will know whether or not Proposition 8 will remain in the California Constitution. And there's a chance it might not, in which case same-sex couples can start getting married again. The other case, though, is more directly a tax case. The case is the Windsor case. It's Windsor against the United States, and it involves an estate tax claim. Edie Windsor lost her spouse there after they'd been married for a couple of years in Canada, living in New York. New York recognized Canadian marriages, and so when her spouse died, this was years ago when the exemption for estate taxes wasn't quite as high as it is now, she owed estate taxes, the estate owed estate taxes, over $300,000. If the marriage were recognized, of course, she could claim a marital deduction. If she claims a marital deduction, there will be zero taxes. And so that's the issue that's before the Supreme Court in Windsor. And the real question is whether or not the Defense of Marriage Act is constitutional under an equality rule contained basically in the Fifth Amendment.
The Equal Protection Clause or whatever.
Well, there's no Equal Protection Clause in the Fifth Amendment, but the Due Process Clause of the Fifth Amendment, which applies to the federal government, is presumed to carry the same equal protection analysis that the 14th Amendment does.
Oh, okay. All right. And like you said, though, this is kind of interesting, these cases, both of them, because the federal government even, as far as the Obama administration and the Attorney General's office, basically they said, we've looked at it, we think that DOMA is unconstitutional. And so for both of these cases, really, the people who are taking it to the Supreme Court and trying to enforce DOMA are parties other than the government.
Yeah, the DOMA situation is very unique. President Obama and Attorney General Holder, after doing a close analysis of the Defense of Marriage Act, came to the conclusion that it was violating the Constitution. So the Obama administration has taken the position that they will not defend it in court. That means the Department of Justice, who defends the government, is not defending it in court. But at the same time, President Obama instructed all of the administrative agencies, including the IRS, to continue enforcing DOMA. If they weren't enforcing DOMA, Edie Windsor would have gotten her refund. She would have gotten her marital deduction. So the IRS is enforcing DOMA, but it's in court, and the Department of Justice is not defending it. So once again, and this came from the Supreme Court itself, they've asked for additional briefing in the Windsor case about whether or not, one, the Bipartisan Legal Advisory Group, BLAG, that's the House of Representatives group that is defending DOMA.
Yes.
And the question is whether they have standing to defend DOMA. And the other question is a little bit different. It is, since the government agrees with the plaintiffs in this case, and since the government is the party on the defendants, basically, if the parties agree, how can there be a case or controversy under Article 3 of the Constitution? We may not have jurisdiction to hear this case. Well, of course, since the administrative agencies are enforcing it, and since Edie Windsor has not gotten her refund from the IRS, I think there's clearly a case of controversy there. So I'm hopeful that they will reach the merits, because otherwise we're in a big mess of not knowing what the law is.
Okay.
And I was just at a conference this past weekend at UCLA discussing this issue. And I'd say the overwhelming consensus of the law professors who work in the constitutional law area was that there's a very good chance that the Defense of Marriage Act will be struck down by this June 2013.
Okay. Well, it'll be interesting to see how this drama unfolds. Okay. Well, anyway, so here we are. We've got this uncertainty in front of us. Hopefully, though, we'll have a conclusion in June. One good piece of news related to that, in a sense, is we can file extensions for tax returns for this year. So, maybe we could wait until we've got a conclusion.
Now that's a very interesting question, because there are two possible results if the Defense of Marriage Act goes away. Mm-hmm. That is that there are some taxpayers who will be better off filing joint returns, and there are some people who will be worse off filing joint returns, especially two earners with high incomes, because once you get into the alternative minimum tax and the upper tax brackets, you will actually pay a federal tax penalty. Mm-hmm. If I just did the numbers for someone with $2 million of income, split $1 million each, compared to if they file a joint return, and they're going to pay hundreds of thousands of extra dollars just
especially
because
with
they're married.
these new tax rates that are in effect.
Sure, for 2013.
For 2013. I mean, it's going to make a big difference.
But even for 2012, there will be a marriage tax penalty. Okay. So some people are suggesting, if you think that you're going to pay a marriage tax penalty, please try to get your tax returns in before June, before the case is handed down. Because if the case is handed down and says the Defense of Marriage Act no longer exists, and you haven't filed your return yet, now suddenly you are viewed as being married and probably ought to file jointly.
Okay. Related to this, will married be the same as a registered domestic partner, do you think?
Oh, wow. That is, of course, an interesting question, because the code uses the word spouse.
Yes.
Right now, spouse cannot include same-sex partners, so we haven't had an opportunity to raise the issue of, well, are registered domestic partners the same as spouses under federal law? Yeah. We know they're treated the same as spouses under state law, but we have no idea how they'll be treated at the federal level. There was a letter, an informal letter, that resulted when someone from H&R Block in Illinois, Illinois passed civil unions, which are like California's registered domestic partnerships, but in Illinois, they're equally available to opposite-sex couples. Mm-hmm. So someone from H&R Block wrote to the commissioner and said, if I'm doing a return, a federal return for opposite-sex civil union partners, do I file jointly, or are they treated as single at the federal level? And he got a letter back from somebody in the Office of Chief Counsel saying if they're treated the same as spouses under state law, then they should file jointly at the federal level. A lot of people have taken that as evidence that the IRS will intend to treat registered domestic partners and civil union partners the same as spouses. But I think there's a little more thought that's got to be given to that issue.
And part of the thing is, like you said, I mean, everything's informal right now. We've got letters and so forth. These aren't regulations.
There's nothing that can be cited as authority.
Yeah, right. Okay. Well, what do we do about our 2012 tax returns?
Yeah, well,
even if we,
we don't know the future, and if you don't go on extension, if you're filling out tax returns now for 2012, you have to follow the existing rules. Now, you can take the position that DOMA is unconstitutional, but I think that would be better to do on an amended return than an original return, because we know the IRS is enforcing DOMA. So in California, as well as in the state of Washington and the state of Nevada, where same-sex couples are subject to community property rules, you have to split the community income and the community deductions. Now, we've had some experience with this over the past couple of years, and it's created some problems. A lot of people at the IRS, especially out in the field, are not clear about what these rules are. And they've generated a lot of CP 2000 letters because we ended up with an adjustment on line 21, and for some reason that seemed to trigger CP 2000 letters questioning what that item was and whether it might be self-employment earnings.
Yeah, this stuff doesn't all work good with computers. I mean, it's all right to talk about you know, these concepts and so forth, but when a computer is trying to match a W-2 to a tax return, and half of the income is ending up on the tax return,
well, exactly,
it's going to spit things out.
Exactly. So the IRS has now proposed a new form, and it was in draft form for the longest time, but it's finalized now. That's Form 8958, which is going to be their official form for splitting the community income. And it's, you know, if you go onto the web and just Google Form 8958, yeah. You should come up with it. And there are directions. The directions are not good. I did hear just today that the IRS is going to do some focus groups in areas where there are a lot of returns like this. So there'll be one in San Francisco, trying to get the word out to practitioners about exactly how to do this. So stay tuned to the IRS websites for some announcement of these workshops.
Yeah. So related to this, folks, of course, the IRS has its own website. It's www.irs.gov, and there's some nice buttons on there that says Forms and Publications. And so if you go there, and then you can search 8958, look under current year forms, and you'll find it. And so you'll see that basically what it says is, here's what's the total, and here's how much is going to each of these taxpayers.
What it doesn't do, it doesn't give directions about exactly how you report it on the return. If you read what the little bit that they say, it sounds like you're supposed to report 50% of all earnings on one return for one partner and 50% of all earnings on the other partners. But as you just mentioned, we think this will, you know, drive the computers crazy, because if my W-2 has my Social Security number on it, then it ought to be on my tax return. So we've always recommended that you split it on the spreadsheet, and I report 100% of my wages, but then I make an adjustment on line 21 called a community property adjustment, where I take off 50% from my line and add 50% to my partner's line, and then do the same thing with her wage income, and the same thing with self-employment income. Although we've got a little bit of a disagreement with the IRS on self-employment income and self-employment taxes.
Right, because for self-employment, usually, if I have a business and I'm the one that's conducting it, all that self-employment income goes on my tax return because it relates to my Social Security benefits.
Right, right.
Whereas
you pay the self-employment tax on it, which gives you credit for Social Security.
And then half of the income still goes to my wife, you know, in Schedule C if we did separate tax returns.
But she doesn't pay any self-employment tax.
But she wouldn't pay the self-employment tax. But they're suggesting
but they take the position for same-sex couples that because of the Seaborn case, which says everything must be split. Now, there was no Social Security or self-employment tax in the year of Seaborn, so Seaborn really doesn't apply to this sort of thing. But they say it must be split 50-50 unless the statute itself makes a different assignment. And unfortunately, the statute at play here, Section 1402 of the Internal Revenue Code, says in community property states, the spouse who earns the income will report the community income for self-employment tax purposes. Because they use that word spouse, and because of the Defense of Marriage Act, the Chief Counsel says that rule cannot apply to same-sex couples. Therefore, the Seaborn splitting rule applies, and each of you must report 50% of the self-employment. I think that's wrong. Okay,
okay. So, I mean, I was talking to one of my friends who does some of the same-sex couple tax returns. It makes it sound like he was playing Atari or something, you know, one of the video games when he's deciding where to put deductions and so on. And I said to him, you know, well, wait a minute. I mean, we've got community property concepts here. I mean, really, it should be 50-50 if it's paid from community
It should be 50-50 if it's paid from community funds, but then you end up with certain problems. What if partner O owns the home, has title as separate property, and then they use community funds to pay the mortgage payments. Well, that's an interest deduction,
Yes.
and there's a property tax deduction that might be paid out of community funds as well. But the rule is that partner B can only deduct interest and property taxes on property that he has some ownership interest in. Could be an equitable ownership interest. Now, I think under California law, once you've paid $1 of principal out of community funds, the community has an equitable interest in that property. But if you've been paying interest only, and you haven't made any principal payments out of community funds, you are literally using community funds to pay for separate property. And the IRS, I know, in a couple of instances, has taken the position that you lose half the deduction. Now, I think if partner B is paying my interest and my property taxes, then I think partner B is making a gift to me. Could be taxable. Hopefully it's not in excess of $14,000, which is the exemption this year. And then I'm using that fund to pay my own property taxes. And there's actually a tax court case called Judith Lang, L-A-N-G, that stands for this proposition. And it was a case where a mother paid the medical bills of her daughter, and the IRS didn't want the daughter to take the deduction, and she won in tax court on the theory that her mother had gifted the money to her and she had paid her own medical expenses.
Yeah, the courts tend to be a little more sympathetic on, I think, on some issues like this. It seems like you can't count on it. But anyway,
Right.
And then what? Then you got to pay attorneys in order to get it into court and settle the issue. Oh, rats. Okay.
And then there's just one other quick thing that people might want to know about. This is for the more wealthy taxpayer. You may recall last spring there was a tax court opinion in a case called Sophie, where a same-sex couple, unmarried, owns a home together, a home with over $2 million in mortgage indebtedness, and the limit is $1.1 million. That's the amount that you can deduct interest on. I always thought that that limit was applied per taxpayer. The tax court held it was per residence, not per taxpayer. And so the two unmarried individuals were subject to the same limitation as a married couple. A married couple can only deduct mortgage interest on a total of $1.1 million of qualified debt. I think that's wrong, and I'm working with a group now through National Center for Lesbian Rights and some pro bono counsel. We've intervened in the case and are appealing it to the Ninth Circuit. So,
well, if you're married, then that's going to take care of that issue too.
Well, but this is for loads of people who are not married throughout the country. This is not a married couple. We have another case that the couple is not even registered domestic partners. I know of instances in San Francisco where two families, because they couldn't afford it otherwise, have bought a home together that cost over $2 million because it was where they wanted to live, and they're simply tenants in common. If it's per residence, then they're taking away deductions I think each family ought to be entitled to.
So we'll see how that one settles out too. So sometimes it takes, unfortunately, it takes an awful long time to settle issues. And meanwhile, people have to make decisions while they're preparing income tax.
It would be good to have some clarity. And I think if DOMA is struck down as unconstitutional, the IRS will be in a much better position to start giving us more official pronouncements about what the law should be in this area.
Okay. So what about, you mentioned there's an issue related to the adoption credit?
Oh, yes. Well, the adoption credit for 2010 and 2011 was refundable. Because it was refundable, there were lots of audits of the returns. In fact, the National Taxpayer Advocate, Nina Olson, in her recent final report to Congress, complained about the unnecessary number of reviews that were done on the adoption credit. Something like 60% of all taxpayers who claimed the adoption credit at least had an audit by mail. There's some that are still outstanding. And then what we have discovered is that people in the field don't understand the credit. So they have denied it to same-sex married couples on the theory that if you are married, you cannot adopt the child of your spouse. That's what the statute says. But because of DOMA, of course, it doesn't apply to same-sex couples. But they've used that theory to deny the adoption credit to couples who aren't married, who aren't even registered. And they've used a lot of different theories. The one I just heard about is a joint adoption by a same-sex couple, but they paid the adoption expenses out of a bank account listed in one taxpayer's name. Now, it was all earnings, it was in California, it was community property. But the agent will not allow the other taxpayer whose name was not on the account, will not allow him any of the adoption credit. This one is probably going to appeals, and we may settle it. But look out for the adoption credit, and wherever possible, if you're paying for adoption expenses, pay for them in a form that looks like it came from your money.
Okay. So we're running out of time. One thing that before we conclude that I want to mention to people too is that there is a pretty good IRS publication about community property. So again, if you go to that IRS website and you go, again, to Forms and Publications, and now there's a tab there and it says Name, or something like that. And there's one that says Number and there's another that says Name. So you want to be at Name and you put in Community Property. Do you remember what the publication number is?
Publication 555.
Okay, Publication 555. Anyway, so you can look it up either way. Get a copy of that publication. That will answer many of your questions related to community property.
Many, but not quite all.
Not quite all. So anyway, community property is a very complex area. Pat, we just have, maybe a minute and a half or less. Maybe you'd like to throw out a final thought as we finish up here.
Sure. Well, also, as long as we're on the IRS webpage, remember that there are FAQs, frequently asked questions, and there's some questions and answers that deal especially for same-sex couples and for registered domestic partners in community property states. So if you do a search on the IRS webpage for same-sex couples or community property and registered domestic partners, you will find those Q&As, and they are very helpful.
Yeah, I remember I saw that list that you gave to us at one of the conferences. So folks, this is an evolving area for same-sex couples. I've enjoyed having Patricia. Thanks so much for being with
Thanks for asking
me here. She's one of the people that we in the professions look to for keeping up in this area. She's harassing the IRS all the time. But anyway, so we'll do our best to keep you up to date from time to time. We'll see you next time on Financial Insider Weekly.